People who are crazy enough to think that they can change the world are the ones who do.
Okay. So counsel, I presume you're okay if I get you taken real quickly out of order so we can get the jury back to deliberating? Okay. So we're going to call case 831-543 Hunwardsen versus Infinity Lifestyles, DBA Real Water. And so counsel, please just say who's present, please.
Your Honor, Will Kemp, Theodore Parker, Eric Pepperman for Plaintiffs.
Good morning, Your Honor. Joel Odou, Mark Love, and Eric Freeman on behalf of the Real Water defendants.
Okay. So folks, as you know, we have a media request, so this is being recorded. Oftentimes with a jury question, because it's in the middle of deliberations, I ask the parties whether or not, because that's normally something that's not recorded, but sometimes people are fine with it being recorded what the actual question is in the middle of deliberation. So I leave that to counsel to.
Your Honor, I think it's public courtroom. They always seem to record this part.
It's fine with us, Your Honor.
Okay, fine with the court, of course. Okay, so the juror question that was presented is the past loss earnings stipulated? And so I appreciate we tried to do it like quick on a post-it, but I think it probably makes more sense to make it clear on the record. So I received back that the answer was yes, and then you have the amount of said stipulation, which is $170,238. Do you wish anything to be placed with regards to a playback of a recording for the jury to come in, or do you wish the court to basically post it with you all's signature on the question that came from the jury and have the marshal hand that back to the deliberating jurors, or you wish some third option, not limited to those two options? Tell the court what you would like to do and I'll consider it.
Second option, Your Honor.
Real Water agrees to post it back to the jury is fine.
Okay, is that counsel for
Yes,
plan?
Your Honor.
Okay, so then what the court's gonna do is, we're just gonna hand this to the marshal as is, the nice little yellow post-it that says is past loss earnings stipulated. It says yes, and it has the amount, and then has each of your signatures, and then we'll make this part of the court record. That's the only question the court's aware of at this juncture. Is there anything else the court can do for you on Hunwardsen matter?
No, thank you.
Thank you.
Appreciate
Thank you very much,
your
Your Honor.
promptness coming. Okay, hand it to Marshall. Back on the record, since I called an intervening case since I saw you last a few moments ago. Back on the record in case 831-543. Sorry, counsel, I need you to make your appearances again, please, just since we have intervening matter.
Good morning again, Your Honor. Teddy Parker, Will Kemp, and Eric Pepperman on behalf of plaintiffs.
Good morning.
Hey, I'm sorry, and Brianna Switzler, too.
She was here?
She was.
She's right outside the door.
No worries, okay. Close
Joel
enough.
Odou, Mark Love, and Eric Freeman on behalf of the Real Water defendants.
Okay. So counsels, just to let you know, the jury notified the marshal, who in turn notified came up and told my JA, which then told the court that they were anticipating that they're going to be deliberating at least through the lunch hour. So we just wanted to give you that heads up as a courtesy. And so what will be writing them.
Judge, I think we'll just come back and one if that's okay with you.
It's fine with the court if we know something earlier, then we will let you know, because presumably, I guess the question was asked before I went on the record was, what does the lunch hour mean?
Okay.
I'm conveying what the statement that I heard third hand was, and so if you wish the marshal to ask them what they meant specifically with that, we would do so, but normally we wouldn't. Normally we assume the lunch hour is somewhere around the noon that they need the next couple of hours, but.
Yeah, Judge, can I ask a question?
Of course you can, go ahead please.
I've seen occasions where the jury pretty much done and they want to go have lunch, so they have lunch with each other and the verdict's really pretty much done, so that you get it right after the lunch hour. I've seen that happen quite a few times. Assuming for the sake of argument that does happen, what's the court scheduling for the punitive phase?
That's what I was going to ask you next. I was trying to give you that quick heads up and then see where we're going to go for what you all want to do. As the court indicated yesterday, for the needs of this case, the court canceled everything for the afternoon, so we have the afternoon for you to ensure that you can get things taken care of.
We're ready to roll into it, Your Honor.
Presumably, but I was going to check with all counsel because initially, as you knew, there was. Marshall, can we see, is that one of you all that went to the ante room?
I'll find out, Your Honor.
No worries, it's just, okay.
Someone getting their binders, you know.
No, that was,
No worries.
Mr. Godfrey's assistant.
Oh, okay. I just want to make sure that someone didn't think that they had another matter. So I was going to check with all parties to see if that's what you wanted. The court was, generally people do, so we were moving everything and getting everything taken care of so that you could have the afternoon. Is that what the parties were requesting, or did somebody say that in light of the fact that you thought we were going to be dark, that somehow somebody is prejudiced or disadvantaged if we continue with the punitive phase this afternoon?
Joel Odou for Real Water. No, Your Honor, we're prepared to move forward. It was, one of the issues was whether it was going to go straight into argument or if there would be additional evidence offered. Plaintiffs last night indicated they were thinking about it. We're just curious if a decision has been arrived at for planning purposes.
Yeah, we decided not to offer any further evidence, we'll just roll straight into argument.
And then we will do the same, just so the court's aware for planning purposes.
Okay, so both parties are amenable to doing that?
Yes, Your Honor.
Now, when you use the term argument, sometimes people mean that before we go in front of the jury, or sometimes you mean just straight in front of the jury. So can you just clarify what you're talking about? Meaning, is there anything that you need from the court outside the presence of the jury, or you're just saying straight argument in front of the jury, and then they'll get a new verdict form if it goes to a second stage?
Exactly.
You know,
We agree, Your Honor.
Okay, no worries. Like I said, people have different meanings sometimes, so I asked the clarification question to make sure we're on the same page. So, to Mr. Kemp's initial question about 1 p.m., that does seem to be feasible and doable. Now, I could say those words and 10 minutes later the jury can say we have a verdict, and then I would need to call you right back. But I think that's a reasonable thing. The reason why they normally let us know around the 11 o'clock hour is just realistically, if they're thinking of going through the lunch hour, there needs to be some time allocated so that said lunch can be ordered, right?
Mm-hmm.
With the very limited resources, and there's only a couple places that are on vouchers, and they can take a while, so.
they always eat lunch, Your Honor.
We ensure
Good.
members of our public who
They
do
deserve
the
it.
trial, that, you know, they get an opportunity to have everything
least we can
possible.
do.
We just need to make sure that we give you all the heads up. Okay, so if another question comes, we'll let you know. Here's my question to you all. If it's another question that was similar to that last question, right, which is a simple yes or no question, right? Do you all prefer to come back here? Do you prefer if there's some other option?
I think
What are you requesting?
it was a super simple question, I think Mr. Parker and Mr. Odou could solve it on the phone.
I suspect we could, Your Honor. We're going to be within walking distance. We're going to walk to a restaurant and have lunch while we wait. But we will be very close by. But if it's a simple yes or no, I have no objection if Mr. Parker is here first to call me and say, here's the question, and we can resolve it on the phone most likely.
That's fine with me. Mr. Odou has my cell. He's had it for a long time. Either way.
And you know, part of the reason why I'm asking is I appreciate you also have people who are observing all different things. I want to make sure everybody's taking care of it. You all have that covered from each side, so, okay?
I believe the people who are observing are not from the defense offices. They're probably from other parties who are curious. So,
It's a public courtroom, I realize.
Exactly.
You can tell I went straight from my motion calendar in between, back and forth with you all, so I'm not really looking exactly who's on the monitor. I just take care of every minute on my docket. So, okay, so then at this juncture, jury's gonna be back in deliberations. We're gonna get them taken care of. We're gonna estimate you all will be back at 1 o'clock. If it's something sooner or later, we get a heads up, we will let you know. And then the understanding is that once they come back, they'll come back in here and want the verdict read. We'll address what needs to be addressed. And then I will either send them back to the deliberation room and I have you all touch base for a moment to confirm that you're still on the same game plan of going straight to argument for punitives, or depending on what the time frame is.
Sounds great, Your Honor.
I just call you. I
Thank you.
appreciate it. Thank you so much for your time, everyone.
Thank you, Your Honor.
We're on the record outside the presence of the jury in case number 831543. Counsel, I am going to need you to do your appearances, please.
Good afternoon, Your Honor. Teddy Parker, Eric Pepperman, and Will Kemp on behalf of plaintiffs. We also have all of our plaintiffs here, Ms. Schaefer, Ms. Hartshorn, Ms. Brody, Ms. Hunwardsen, and Ms. Sosa.
And you also have one more counsel.
And we have Brianna. Brianna, I called you when you weren't here, and Brianna Switzerland, Your Honor.
No worries. Counsel for Real Water, go ahead, please.
good afternoon, Your Honor. Joel Odou on behalf of the Real Water defendants with Mark Love, Eric Freeman, and Matthew Kaufman.
Let Okay, well, the marshal has been notified that we have a verdict and the jurors are going to be lined up and coming in just a moment. While we have a brief moment before that happens, we need to take care of a couple of quick administrative matters. We said yesterday before we went off the record that I was going to state that the clerk was going to release the depositions that were not opened in open court, they were not published. And so counsels for plaintiff, can you just arrange in the next week for someone to come pick up and having all your depos released to you that were not published?
Yes, Your Honor, Eric Pepperman for plaintiffs. Should I have, will there be a place where I should direct them to pick everything up?
If they contact the department, my JEA, she can let them know. You can get that arranged sometime the next week, okay? So,
Yes, will do, Your Honor.
appreciate that. And counsel for real water, we understand you might have 5 depositions approximately. So
Sounds right,
sometime
Your
next week, can you just arrange to get those taken care of as well?
Will do.
Appreciate it. Okay, with regards to the motion for good faith settlement on the other party, it did come in today. Court signed it immediately upon seeing it. We do not have a notice of entry of order, but from yesterday's statements of all the counsel in open court, I understand that that should not hold up anything, right? You're treating as if there was a notice of entry of order. Is that correct, counsel?
That is correct, Your Honor.
Is that true, counsel for the water?
Yes, Your Honor, it is.
Okay, thank you so much. Okay, with regards to any of the exhibits that were proposed but not admitted since they were in electronic format, they are on a drive, and so therefore there's nothing to return to the parties because there was no paper copies of anything that was proposed and not admitted. So we don't have that issue. Then right now, is there any other matters that the council wish to address on the record outside the presence of the jury? Because what I understand is once the jury comes in and they read the verdict, depending on that verdict, and by the way, the clerk does read the verdict word for word in its entirety. And then after we have that verdict read, we will call you to bench and confirm what you wish to do, if there is a next step, and if so, what to do with regards to that next step. Does that meet the needs of council?
It does, Your Honor.
Yes, Your Honor.
Thank you. And Marshall, is the jury ready outside?
Yes, Your Honor.
Okay, everybody ready for the jury to be brought in?
Yes, Your Honor.
All rise for the jury, please.
Come on in, folks.
Your Honor, all members of the jury are present. Everyone, please be seated.
Appreciate it. Thanks so much. Welcome back, ladies and gentlemen. Hope you've had a very nice morning and part of your afternoon. At this juncture, it's the stage of the trials where we talk about the verdict. The court will note and the record will reflect the presence of plaintiffs and defendants and their respective counsels. Do the parties stipulate to the presence of the jury?
We do, Your Honor.
So what do we do for real water? Yes, we do.
Okay. Has the jury elected a foreperson? And who is that foreperson, please?
It's me, Your
Thank you so very much. Will the foreperson please hand the verdict to the marshal? The marshal, in turn, just to let you know, will hand it to the court. The court just reviews it real briefly, and then it's going to be handed to the court clerk, who will then read it word for word. Thank you so very much. Okay. Madam Clerk, I'm handing you the verdict form. Can you please read the verdict?
District Court, Clark County, Nevada, Myles Hunwardsen, individually, Jasmine Schaefer, individually, Tina Hartshorn, individually, Miriam Brody, individually, and Christina Sosa, individually, plaintiffs, versus AffinityLifestyles.com, Inc., DBA Real Water, a Nevada corporation, Real Water, Inc., a Delaware corporation, ETT1, LLC, DBA Terrible Herbs, a Nevada Limited Liability Corporation, defendants. Case number A-21-831543-B, Department number 31, verdict form. We, the jury, return the following verdict. Compensatory damages. Fill in the amount of compensation that you deem appropriate for each plaintiff's compensatory damages. Myles Hunwardsen, damages. Past physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, $2,500,000. Future physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, $3 million. Past loss earnings, 170,238. Future loss of earnings, 2 million. Loss of life expectancy, 14 million. Jasmine Schaefer damages. Past physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 1 million. Future physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 1 million. Future medical expenses, 50,000. Tina Hartshorn, damages. Past physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 1 million. Future physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 1 million. Future medical expenses, 50,000. Christina Sosa, damages. Past physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 1 million. Future physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 1 million. Future medical expenses, 50,000. Miriam Brody, damages. Past physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 1 million. Future physical and mental pain, suffering, anguish, permanent injury, and loss of enjoyment of life, 250,000. Future medical expenses, 10,000. Punitive damages. You must also determine plaintiff's claim for punitive damages against Real Water. 1. Is Real Water liable for punitive damages? Yes. Dated the 6th day of February 2024, jury four-person, badge number 61, panel number 18. Ladies and gentlemen of the jury, was this your verdict as read?
Yes.
Thank you. Do either of the parties wish the court to poll the jurors?
Not on behalf of the plaintiff, no.
Not on behalf of Real Water, Your Honor, thank you.
So ladies and gentlemen of the jury, what that meant is when the court said we're polling the jurors, is sometimes the parties will ask that each individual juror is polled to ensure that it's his or her verdict as read, to ensure that we have the 6 of 8. Since neither counsel has requested on behalf of their parties, the jury will not be polled. Then at this juncture, the clerk will now record the verdict in the minutes of the court, and we'll now then need to go to the next step. Counsel, can I have you approach please for a brief moment? We turn on some white noise, please. We've been informed that there's a punitive damages phase. That's a separate phase. So what we're going to do is we're going to send you out on a brief 15-minute break while counsel prepare for the punitive damages phase. Then you're going to come back in. Each of the counsel will have an opportunity, since the plaintiff will have the same opportunity to go first. They'll be able to present what they wish for a punitive damages phase. Counsel for Real Water will then need to have an opportunity to respond to the extent that they wish to do so. And then there's a rebuttal case on behalf of plaintiff if they wish to do so. So ladies and gentlemen of the jury, what we're going to do is we're going to go back to the jury deliberation room. Because there is an intervening between the phases, I am going to read you the admonition, because at this juncture there shouldn't be anything to discuss with regarding to the case until you hear the information, the evidence presented, and the argument presented with regards to the punitive damages phase. Does everyone understand that? Okay, let me just read it so that you have for clarity. Okay, so ladies and gentlemen of the jury, during this recess before we go to the next stage of the trial, you are admonished not to talk or converse among yourselves with anyone else on any subject connected with the trial. You must not read, watch, or listen to any report of or commentary of the trial, or any person or entity connected with the trial by any medium of information, including without limitation, social media, text, tweets, newspapers, television, internet, radio. Anything I've not stated specifically is, of course, also included. Do not visit the scene of the events mentioned during the trial. Do not undertake any research, experimentation, or investigation. Do not do any communications on any social networking sites or anywhere else. Do not do any research, including but not limited to internet searches. And please do not form or express any opinion on any subject yet not presented to you until you have an opportunity to deliberate on that full and finally in the jury deliberation room after the completion of the punitive damages phase. Thank you so very much. We'll come back in about 15 minutes. Thank you so much.
All rise for the jury, please.
Thanks very much, Counsel. I'm about to go off the record, but if you all do all need to stay in here, if you wish to stay in here in order to prep for your arguments, that's fine to do so. The court's fine to stay in here. If you want to use the anteroom, you're more than welcome to use the anteroom or be out in the hallway. Whatever you wish, just let us know when you're ready to go back on the record, okay?
Thank you, Your Honor.
Thanks so much. The jury, the court has been handed the following. a document entitled Jury Instruction for Phase 2 Amount of Punitive Damages. I understand that while the court made a ruling with regards to the two alternatives proposed for said instruction, this is the one that was handed to the court that's now blue-backed is consistent with the court's ruling. And I appreciate that's over the objection of real water. But is that correct, that that's the instruction to be read to the jury?
Yes, Your Honor, it is.
Yes, Your Honor.
Okay. And the second document provided to the court was a document titled Punitive Damages Verdict. And the court's understanding is this is the verdict form that will be provided to the jury for their deliberations in Phase 2. Is that correct?
Eric Pepperman for plaintiffs. Yes, Your Honor, correct.
Joel Odou for real water, that is correct, Your Honor.
And this verdict form was agreed to by the parties, correct?
Yes, Your Honor.
Yes, Your Honor.
Okay. So now I have a couple, and I understand that Counsel for Real Water, you're going to be submitting a proposed jury instruction for the punitive damage phase that was offered but not admitted, and that can be done while the jury's out at deliberations, correct?
Yes, Your Honor.
That meets your needs, and Counsel for Plaintiff, you concur, is that correct?
Yes, no objection, Your Honor.
Okay, thank you. So then the next quick question for you all is, you previously had stated you wanted to go straight into argument with regards to the punitive damages phase, which means one or two, a couple of different options. Generally, if there is an evidentiary phase, you would go through the evidentiary phase, as you know, then the court would read the jury instruction, and then you would do, in essence, a closing argument. Since you all have stated you just want to go straight to argument, do you want the court to, when do you want the court to read the jury instruction is really where I'm coming with this one, right?
No,
Your Honor, I think you have to do it before we start arguing.
we agree.
Okay. Perfectly fine for the court, I just wanted to, particularly if you all were planning on using it in your arguments, but I just wanted to make sure that was. So Jill, I'll give you a moment if you want to provide that. Marshall's the jury waiting, ready? They have their notebooks in hand?
Yes.
Perfect, thank you so much.
Thank you.
So if you want to wait till after their deliberation, so you're not addressing that right now, or if you're prepping for your argument, that's fine, or it's fine with either option. Which do you want to do?
It's
I
ready
can
to
wait,
read.
how, pardon? No worries, I can wait if you want to do it now, or I
We can
can.
do it now, Your Honor, we're ready, I'll distribute the copies.
Okay, so we'll wait a moment, let the jury just could wait a moment.
No.
Just give me a quick second.
Okay.
I appreciate it, thank you so much.
This will be the jury instruction I've given as of today.
Okay, thank you.
Appreciate it. Okay.
Any questions?
Yes, sure, of course. So just have to report.
Make sure you don't want that signed, and not probably as good as sorry. No, okay, I was rushing. Got it right.
Okay, thanks. Okay, so what the court understands, Mr. Odou, you just handed to the clerk was the proposed instruction that was not to be read pursuant to the court's order, is that correct?
Yes, Your Honor, and it has a certificate of service, but obviously we're doing it in open court.
And you handed a copy to counsel for plaintiff?
I did, Your Honor.
Okay, counsel for plaintiff, you concur that that's the instruction that was proposed but not going to be read pursuant to the court's ruling?
Yeah.
Court's indulgence, I'm looking at it right now, Your Honor.
Sure. This is the 12.1 with the other language, right?
Yes, Your Honor,
Okay.
everything after the comma is in that one.
Eric Pepperman for plaintiffs. Yes, Your Honor, this is the same one that was discussed earlier.
Okay, thanks, and you're okay with the handing, the delivery?
Yes, Your Honor.
Okay, thanks for that. Okay, so when the marshal kicks his head right back in, then we'll bring the jury in. I'll explain to the jury that similar to what in the initial phase, that the court needs to read a jury instruction, and I read it word for word, and it goes back with them, and that is the law that they're to apply to the case. And then by agreeing of parties, then you'll engage in the argument with regards to the punitive damages phase. Plaintiff, are we doing two plaintiffs or one plaintiff? Two counsel, one counsel?
This one, yeah.
Okay. And then, Marshall, we are ready to bring in the jury panel. Thank you so very much.
All right.
Monday, everybody.
Your Honor, all members of the jury are present. Everyone, please be seated.
Appreciate it. Thank you so very much. Okay, ladies and gentlemen of the jury, thank you for your first stage of deliberations. As we stated, there's now a phase 2. And the phase 2 of the case What happens is, if you recall, right before you went back to deliberations and before closing arguments, in phase one, the court needed to read the jury instructions. Similarly, at this juncture, I'm going to ask counsel, would you like me to instruct the jury on the jury instruction with regards to phase two, the punitive damages phase?
Yes, Your Honor, we would.
Joel Odou on behalf of Real Water, yes, please, Your Honor.
Well, unlike the other one that had multiple pages, this one has one page, but I still need to read it word for word, and you will have a copy of it back in your deliberation room. So please do listen attentively while I read it word for word. Thank you so very much. Instruction 1. There are no fixed standards for determining the amount of punitive damage award. The amount is left to your sound discretion, to be exercised without passion or prejudice and in accordance with the following governing principles. The amount of a punitive damage award is not to compensate plaintiffs for harm suffered, but is reasonably necessary to punish and deter the defendant and others from engaging in conduct such as that warranting punitive damages in this case. In arriving at any award of punitive damages, you are to consider the following. 1. The reprehensibility of the conduct of the subject defendant. And 2. The amount of punitive damages that will serve the purposes of punishment and deterrence. So that is the jury instruction. Like I stated, a copy of that will be in the jury deliberations room for you. And at this juncture, then the next phase would be by agreement of counsel. They're going to engage in argument. Counsel for plaintiff has an opportunity to go first, then counsel for defendant, and then counsel for plaintiff has an opportunity to do the final argument if they wish to do so. Counsel for plaintiff, would like to commence with your argument with regards to the punitive damage phase of the case, please.
I would like to, Your Honor.
Go ahead, please.
1 second, Trump. Good afternoon.
Good afternoon.
Mr. Parker, your microphone.
Sorry. You know, it would be strange if I didn't mess this up. Are we good? Perfect. Good afternoon. Again, I want to say thank you. Let me first say that because you guys have hung in there with us a long time. We were crazy enough not to get out of jury duty, and we appreciate it. And I say that not in a derogatory or critical way. I say that because it takes a lot to be a part of this process. You've given up time with your families, you've given up time doing things that you'd rather be doing, but I will tell you it's in the service of this community. And we really appreciate your time, all of us. Mr. Joel Odou, everybody on behalf of Real Water, all of the plaintiffs, we all do. And I was, as I always do, on the treadmill last night. I'm running. And I said, you know, what brings this group together? And I remember the conversations we had back when we were doing voir dire on January 16th. And fate was a part of the questioning. Do you guys remember that? And I said, does it take fate to bring us all together? And it reminded me of something I saw that Steve Jobs said. Now, hopefully you guys know what Steve Jobs is. And he said that people who are crazy enough to think that they can change the world are the ones who do. And I thought about that and I said, you know, I'm asking a lot of this jury. We're all asking a lot of this jury. And we're asking you to make a change. We're asking you to make a change with concerns for water. We're asking you to make a change as it pertains to others who potentially find themselves in this place with a jury with harmed plaintiffs. And we say that because what the jury instruction says. If you could, Shane, could you put the jury instruction on? And it says here, and we agree with everything the court just read to each of you. There are no fixed standards for determining the amount of punitive damages, punitive damage award. There isn't. There's no formula that we can give to you. We can suggest numbers as we did in the compensatory part of this, but there's no formula. There's nothing that we can say, you multiply this by that. We can't do that. We're going to suggest numbers. I'm going to suggest a number. And at the end of the day, you collectively will determine what the appropriate number is. But the amount, like it says, the amount is left to your sound discretion to be exercised without passion or prejudice. Plaintiffs aren't asking you to be moved by passion or prejudice. We're asking you to use your reason, your understanding of the evidence that's been presented to make this determination. We don't want you to make a determination based upon you feeling some form of sympathy. We want you to make a decision based truly on the evidence. Because you have seen now over 16 days Real Water's complete and deliberate disregard for every safety flag that was flown. And that's what we want you to use to make this determination. Because it's about real water. And if you could you go to the first page of this, the actual caption of this, and blow up just the defendant side of it? There we go. As you can see, Real Water is not only a Nevada corporation, but it's also a Delaware corporation. This decision has an impact both here, sending a message to Real Water in Nevada, but also Real Water in Delaware. When I said earlier that the world is watching, this message has to send, the message has to be to the world. When it says, it says others. I'm sorry, could you go back?
Counsel.
Jane, could you go back to the jury instruction? Well, the approach.
Sure.
Please
Please
approach.
approach. One turn mic, please. Action to the word that was used, Counselor. Can I rephrase?
Yeah, of course.
Thank you so much.
I want to refer back to the word others instead of the word, the use of the word world. Others. So, and I showed you the caption so you could see both Delaware and Nevada. But you see the purpose behind punitive damages. And it says here, the amount of punitive damages of a punitive damage award is not to compensate the plaintiffs for harm suffered. So this is not about the harm. We handle that in the compensatory part of it. You've already made that decision. But what is reasonably necessary to punish, that would be Real Water, and to deter the defendant and others from engaging in conduct such as that warranting punitive damages in this case. So it goes beyond just Real Water's defense. In arriving at an award of punitive damages, you are to consider the following: the reprehensibility of the conduct, and that was started in terms of our arguments in closing, when Mr. Kemp indicated the 4 reasons, bless you, the 4 reasons why punitive damages were necessary, why we believed it was appropriate. And then the amount of punitive damages that will serve the purposes of punishment and deterrence. So now, this focuses on the amount, paragraph 2. I want you to look at the business plan of Real Water. And this is just a reminder. This is the amount of money that Real Water was concerned about taking advantage of in this industry. $4.1 billion on the sale of one brand. That's the size, the enormity of this industry. And so when you're considering others, you have to consider what can you do to ensure that others, as well as Real Water in the future, is not engaged in the type of conduct that we've seen throughout this trial. If you could, let me see this timeline, Shane. I've condensed this timeline. You saw it yesterday. The only thing I've added that we didn't go into much detail on was the number of complaints, 25 to 30 complaints between October and November of 2020. That's how many complaints went unanswered before, 3 months later before they did the recall. The only other thing is I added, as you can see, in 18 and 19, Mr. Hunwardsen's hospitalization, as well as Ms. Brody's. And you can see everything that's happened based on just the ones we showed you over the last 16 days. And as Mr. Kemp said previously, the customer complaints were ignored. The complaints of the vice president, Brett Blaine Jones, his own sickness, he ignored it. The multiple times Anthony Randolph, vice president of sales, ignored. Not a single test, not a single investigation, not a single QA or QC person. And so I looked at this because I recall arguments by counsel regarding trying to compare a small company to a big company. And he said this thing about Nestle being a big company, and perhaps we wouldn't do what Nestle does because we're a small company. I heard that. And then I thought about, let me take a look at a comparable small company. So this one was a give me. In-N-Out. In-N-Out started out in California, husband and wife, the Snyders. One store. In fact, the store is right across the street from their own home. He had a loan for $5,000 to start that business. And Mr. Snyder got the lender for this loan. At one point, I'm not going to spend the whole time explaining In-N-Out, but early on, once In-N-Out started going and going well, the lender said, listen, you can make more money if you cut your salaries, the amount of hourly wages you're paying. And he said, listen, Harry Snyder said, I don't want to do that. I want my employees to be happy because together they provide the service. And he also said, and this is what struck me, he said 3 words are the guiding principles for In-N-Out. Quality, cleanliness, and service. From 2006 when they started until 2021 when the recall, they never truly had a HACCP qualified QC or QA person. Never. The 2017 and the 2018 NSF audits prove that. Harry Snyder also said, and what I read about him, was that if any of his vendors, be it meat, tomatoes, lettuce, ever gave him what he considered to be subpar products, cut them off. And he would inspect the leaves, the heads of lettuce, tomatoes, the meat, everything. You compare that to Real Water. Real Water didn't inspect anything. What they will say is, we didn't do the inspections or the testing because no other water company did. That's what you heard. You introduce something new, you test. Because these people will be consuming it. And these people did. And they all got sick. After you hear about complaints, you test. They didn't test. After you hear people getting sick, you investigate. They didn't investigate. They are the complete opposite of In-N-Out, as an example. The other thing that I found to be a tremendous departure from what In-N-Out, Harry Snyder and his wife did, they cared enough to put quality first, as opposed to commercials, coupons, false advertisements. That's what we've seen. Not a single witness took this stand that talked about the quality of Real Water. In fact, it was just the opposite. What you heard was deposition testimony after deposition testimony and live testimony saying how this was the worst place they've ever seen or worked at when it comes to quality or cleanliness. People saying that we should have stopped the line, we should have recalled. There is no other way, in my opinion, to prevent this than to send a message to Real Water and to others that this type of reprehensible conduct will not be tolerated and that there's an amount to pay if you commit this type of misconduct. The other point I want you to consider, and I'll get another chance to talk, but another point I want you to consider is, if you were to not award punitive damages, like I said yesterday, think about the message you are sending. Think about what you're telling new innovators, what you're telling small companies, large companies.
Objection, Leosh versus Cohen.
I will go, John. You want?
Can you both approach, please? Madam Court Reporter. Modify the last sentence.
I will, Your Honor.
Thank you so much.
And
Courtney,
in fact-
Madam Clerk.
In fact, I want to make it even clearer by putting up the jury instruction one more time. If you could, Shane. And go to the second page. Stop right there. Perfect. Oh, go down, go up a little bit more. There we go. So I brought this back on the screen just to refine that last remark. What we're asking you to do, and what this message should be, is to prevent others, or deter others, it says deter, the defendant and others from engaging in conduct such as that warranting punitive damages. So the conduct that we're speaking about is the conduct that we've already discussed. There's no testing, there's no investigation, there's no recall, there's no stop of production. That's the conduct in the face of all of the customer complaints, all of the sicknesses, all of the symptomology, all of those things. So that's what the conduct is that we're trying to prevent. And certainly we're trying to do it for those who would be, those engaging in such conduct. Hopefully you can understand. The only other thing I wanted to talk about now, because I get another chance to speak to you after Mr. Odou does. When you consider how much time we've spent putting before you all of the red flags, I will call them, instead of going through them all one time again, and all of that happening in 2018, 19, 20, and then litigating for 2 years, a message has to be sent in the real water, and others engage in such conduct, that it shouldn't take that much. It shouldn't take all of that, and then the Southern Nevada Health District, the CDC, the FDA, to require you to do something that you should have done on your own. We want you to consider why that message has to be, in our opinion, significant enough to prevent others from doing it. Again, I will suggest what I believe the punitive number should be after Mr. Odou speaks, but I want you to consider what I've said and then in light of what Mr. Odou says as well. Thank you.
Thanks so much. Councilor Real Water, would you like to engage in your argument?
Yes, please. Thank you, Your Honor. Sorry if I twist the podium a little bit.
Sure, you can feel free to leave the podium, or the marshal can assist you if you'd like, or you can get the council table, or the small podium, whatever you'd
I've seen
like.
it done a bunch of times. I'm going to hope for the best. Oh, thank you. Thank you so much. I appreciate it. That's good. No, this is perfect. Thank you so much.
Sorry
Is
about
your- is your microphone on?
It is, let me turn that off. You want it that way, Joe?
Now I'm going to stick by the podium.
Got it.
Good afternoon, ladies and gentlemen. Again, I want to thank you on behalf of the Real Water attorneys here, myself, Joel Odou, Mark Love, Matt Kaufman, Eric Freeman, and also on behalf of Real Water, on behalf of Amy Jones, Brent Jones, and Blaine Jones. We really appreciate your taking time out of your life to hear this case and to render a fair and just verdict. I want to respond. I'm going to do my response in two parts, and then Mr. Parker can respond further. I want to first address, well, I want to go back and address that we're deeply sorry that these plaintiffs got sick. There shouldn't have been one drop of hydrazine in that water, not one. Brent Jones never heard of hydrazine. Blaine Jones never heard of hydrazine. Amy Jones never heard of hydrazine. John Marlowe never heard of hydrazine. None of the Real Water people heard of hydrazine. That doesn't excuse making these people sick. It was negligent. The jury has found it's more than negligent, it was reckless. And for that, we're sorry. I want to talk a little bit about, I want to respond again to some of the things that Mr. Parker just said, because I think that we have talked about them several times, but they're worth repeating. You just heard from the plaintiffs that there was not a single investigation. Well, we know that's not true. Mr. Zamora, could you put him on Exhibit 56? And again, this is one of the first complaints the plaintiffs start off with. You've seen this before. It's the complaint at the gas station. You've seen there was a gasoline-like smell. You've seen that somebody from Real Water went to the gas station. They investigated. It's just not the way that Dr. Hutt said it should have been investigated. We acknowledge that. Did they test for hydrazine? No, they did not test for hydrazine. They'd never even imagined that there could be hydrazine in the water. I'll get to that in a minute. That is the absolute problem. That's what made these plaintiffs sick. Is this the one where she didn't scroll to the bottom? I don't have my mouse. Yeah, so again, $700-800 an hour, you think somebody would be paid enough to read the whole page, but apparently Dr. Hutt didn't find that important. They also tested the control samples. So to say that not a single investigation, well, that's not correct. There's one already. Let's go to 57. And I'm not going to belabor the point. Obviously, in 57, they investigated the same complaint a couple of weeks later. Did they figure out it was hydrazine? No, they didn't. Was that negligent? Absolutely, it was negligent. There's no doubt about that. So then we go to Blaine Jones. As you recall, I spent a great deal of time talking to you about Blaine Jones and his GoFundMe video, and the fact that in his GoFundMe video, the doctors told Blaine that they didn't know what made him sick in October of 2020. Does that excuse the fact the plaintiffs were made sick? No, it doesn't. Not at all. And you've already rendered a verdict in their favor. And we thank you for that. They deserve that. But it goes to what the jury instruction talks about. And Mr. Parker showed it to you. I'm not going to show it to you again, but it's to punish and deter the defendant, punish and deter Real Water. And it's the amount of the punitive damages depends on the reprehensibility of the conduct. This isn't somebody doing something intentional. This is somebody doing something recklessly. We found that, and we acknowledge that. So the amount of punitive damages should be for the reprehensibility of the conduct, the not knowing there was hydrazine in the water. Mr. Parker also said that nobody had HACCP training, and this is where I need to, and that's not accurate either. And we talked about this in my closing. Mr. Zamora, can you pull up Exhibit 86, page 3? This is the page we couldn't blow up because it was in a PowerPoint. This is the re-audit in 2019, February. Blaine Jones had the HACCP training. He had it from NSF. Dr. Hutt even agrees that NSF is an appropriate place to get HACCP training. So again, the reprehensibility of the conduct here is not that they didn't have HACCP training, it's that it's the elephant in the room. There shouldn't have been one drop of hydrazine in that water. That's what you should punish and deter them from. Mr. Kemp called it the bizarre way they make water. We wouldn't agree with that, but he highlighted for you that they use the titanium tubes to electrify the water. And that's what caused the hydrazine to be in the water. Lastly, I want to talk a little bit about Exhibit 2090, which is an evidence. It was something that we went through rather quickly. This was part of the video deposition or video testimony of Blaine Jones. It's from January of 2021. So this is a couple of months before the recall. And now I got to decide which glasses or which way I'm going to look. If we look at the bottom of this page, the report has been amended to include EPA drinking water limits presented in a pass-fail format. So you've heard the plaintiffs argue that no testing was done other than biological testing. Let's scroll over to page 3, I think it is. Hang on, I got my copy open. Could you blow that up, Mr. Zamora, the testing that was done, all the different things that real water was tested for? Because, go down further, that second. Trace metals, let's look at all those trace metals. So again, that's not biological testing. This is an exhibit, it's in evidence. It goes to the reprehensibility of their conduct. They were testing for these things: aluminum, barium, cadmium, chromium, copper, iron, magnesium, manganese, nickel, silver, sodium, zinc. Go to the next one, Mr. Zamora. Mercury, arsenic, lead, selenium, thallium. These are all the things that a laboratory or a bottled water maker expects to find in their water. They didn't test for hydrazine. That is a fact we've acknowledged since practically jury selection. That was the fact, that was the one fact, the one thing, the domino, if you will, that's what started this all, that's what made these poor people sick. And Real Water didn't test for it, didn't know to test for it, and they should have known, and you found that. So let's talk a little bit about the other jury instruction that we didn't show you this time around, but it's a jury instruction that still applies. I've read it many times in my previous chance to address you. Statements, arguments, opinions of counsel are not evidence in the case. What I say is not evidence. What Mr. Parker says is not evidence. What Mr. Kemp says is not evidence. Okay? Questions are not evidence. The evidence is the documents you've seen, the people who have sat right there and taken the stand, the people who have testified on the videos. That is the evidence, and that is what you should use to make your determination of punitive damages. In looking at the compensatory damage verdict that you rendered, Real Water hears it, it's fair, it's just. We ask you to be fair and just in your punitive damages award. There are 5 plaintiffs before you. A punitive damages award is a combination for all of the plaintiffs. And we would suggest that something that bears, I'm not going to give you a number, let me just start there. We would suggest that whatever number that you decide is fair and just be based on what you've heard, on the evidence, and not the arguments of counsel. Regardless of what number I would have given you, regardless of what number Mr. Parker intends to give you, that's not evidence. That's not something to make a decision on. Something to make a decision on is the evidence that you have already made decisions on. And we would just ask that you render a further fair and just verdict on the punitive damages. Ladies and gentlemen, I want to again thank you very much. I know this is a huge sacrifice. The court appreciates it, the attorneys appreciate it, and the parties appreciate it. Thank you.
Appreciate it. Thank you, counsel. At this juncture, thank you, counsel for plaintiff. You have an opportunity to do your rebuttal argument in phase 2. Thanks very much. Takes a moment to get all set up back and forth. Appreciate it. Thanks so much.
All right. Listen, I saw you guys laughing. I actually was sitting there thinking, I'm gonna get this right this time. Now, I want to be brief, but it's clear to me, and this is not evidence yet, but it's clear to me that Real Water still does not get it. We just heard Mr. Odou tell each of you that we did testing. We acknowledge now that you've determined that Real Water was reckless. Now it took, again, over 2 years of litigation, 17 days of trial, every one of these plaintiffs being deposed, all of our experts being deposed, experts being brought here. All just to say and try to persuade you by this distraction that we tested for bacteria. Ladies and gentlemen, this is not a case about bacteria. This is a case of hydrazine, a known toxin, one of many toxins listed by the CDC. The CDC didn't make Real Water, but they had enough forethought to say, people are getting sick. Let's do a GMCS test and figure out what's in the water. That's it. This is not that complicated of an issue here. A GMCS test, $200, available in multiple laboratories across this country, And they chose to ignore every red flag. And then they come to you, again, as they did in the compensatory phase, and said, we're sorry, we concede. But we're not conceding that we should have done this test. They're still saying that to this day. And unless you send the right message, that's what they'll say tomorrow, and the next day, and the next day. Because they believe they didn't do anything wrong by not testing for toxins. One of the first things that the CDC did, provided to the Southern Nevada Health District, provided to the FDA. It does not work. Manny Pacquiao said, I'm a simple man, I like simple things. This is a simple case. A simple case. How do you not do, from 2006 to 2021, a GMCS test, and then get up here and still claim that you shouldn't have done one? Is that a company saying that I take responsibility, ladies and gentlemen? Or is that a company offering you another excuse? Another excuse as to why now you should not penalize them by awarding punitive damages. Business plan one more time, Shane. This is why they should have tested, next page please. This is why they should have tested for any potential toxins day one. And it says here, towards the end of it, it says, the functional and enhanced bottled water market was validated a few years ago when Coca-Cola purchased Glacier, which included the vitamin and smart water brands for a significant $4.1 billion. And this is what is really important in terms of 2006. Real Water is not aware of any other company that has a technology that is as effective as E2 technology and is confident that the E2 technology is far superior in taste and health benefits to all competitors. If this is new technology, why aren't you testing the results of your new technology? It's new, all right, because it's water for the first time that included hydrazine. Test it. Test this new technology before you start touting its benefits. Leave that up for a second, please. That's what you do. And that's what they're still trying to avoid taking responsibility for right now. The amount we're asking for is 1/4 of what they were looking to take advantage of. Real Water was trying to position itself to get $4.1 million. We want 1/4 of that. That's what we believe is necessary. And the actual instruction says the amount of punitive damage is not to compensate the plaintiffs for the harm suffered, but what is reasonably necessary to punish and deter the defendant and others. That's the message we want you to send to the defendant and others. One other thing I want to mention. Mr. Odou talked about Dr. Hutt's testimony and how there was an investigation. Again, a red herring. Please look at this bacteria testing that has really nothing to do with this case. Hopefully that will distract you enough not to award something significant. But did Real Water bring a single expert to this stand? Someone who could raise their right hand and give you testimony? Did they bring a counterpart to Dr. Hutt? Did they bring a counterpart to Dr. Hudson? Did they bring a counterpart to Dr. Najam? Did they bring one expert who came to you and explained to you why they should not be held responsible for punitive damages? Just one. You didn't hear from one because they don't have one. They didn't have one. They didn't have one who explained how hydrazine was introduced to their water. They didn't explain to you why they didn't do a GMCS other than the argument of counsel here. No explanation. And they come without any explanation and ask you to forgive them by, I guess, asking you, because they didn't give you a number, to say, something, punitive damages should be assessed, but whatever minimum number you can come up with. Whatever number you come up with, has to fit the circumstances in this case. And it has to be a reflection of how poorly they conducted their business. He talks about Blaine and Brent and Amy and Marlo not knowing about hydrazine. Well, I can tell you 5 people who knew nothing about hydrazine. And I can tell you 3 government agencies who came in and found it quickly. And they didn't create this. The message has to be one that prevents Real Water and others from committing these same reprehensible acts. Because if you don't send that type of message, given that type of numbers that Real Water was seeking to get to achieve through this E2 technology, it could happen again. They could do it again. Again, thank you so much. We await your reasoned decision, and it's been a pleasure.
Thank you very much. Does that conclude the rebuttal argument of counsels for plaintiff?
It does, Your Honor.
Appreciate it. Thank you. Okay, ladies and gentlemen of the jury, what we're going to do at this juncture is just going to check with counsel. As you recall, the marshal was sworn in yesterday to take charge of the deliberating jurors. Does anyone wish the marshal to be re-sworn in, or do you stipulate that the oath that was given yesterday applies equally to today and brings the jury back to deliberations in phase 2?
Your Honor, on behalf of the plaintiff, we believe that the oath administered previously is fine.
Joel Odou on behalf of the Real Water defendants. We agree, Your Honor. Thank you.
Do appreciate that. At this juncture, Marshal, can you please take charge of the jury and bring them back for deliberations? What's going to be brought back into the deliberation room is the jury instruction that you previously provided, a verdict form. You have your notebooks. Please do bring those back with you as well. And thank you so very much. And we'll reach your verdict. Thank you so much.
All rise for the jury, please.
Okay, so counsel, is there any matters that you need while we're off the record? Excuse me, while we're on the record outside the presence of the jury. Sorry, it's been a long couple of days. Anything you need counsel to plan?
Nothing further, Your Honor.
Anything with defendant?
Nothing further, Your Honor.
Okay, appreciate it. Then we're going to go off the record, and you're welcome to either stay or leave, depends on what you think with regards to the jury. Same thing that we mentioned.
All rise. Thank you, folks. Come on in, everybody. Your Honor, all members of the jury are present. Everybody, please be seated.
We appreciate it. Thanks so much. The record will reflect the presence of plaintiffs and defendants and their respective counsel. Do the parties stipulate to the presence of the jury here for phase 2?
We do, Your Honor.
Joel Odou for the Real Water defendants. We do, Your Honor. Thank you.
Okay. Well, I don't need to ask the question about the forepersons, so all I'm going to say is, can the foreperson please hand the verdict form to the marshal, please? Thank you so very much. And Marshal, if you can please bring forward the verdict form as you are doing. We'll take a quick. Okay. So at this juncture, Madam Clerk, can you please read the verdict form?
District Court, Clark County, Nevada, Myles Hunwardsen individually, Jasmine Schaefer individually, Tina Hartshorn individually, Miriam Brody individually, and Christina Sosa individually, plaintiffs, versus AffinityLifestyles.com Inc., DBA Real Water, a Nevada corporation, Real Water Inc., a Delaware corporation, ETT1 LLC, DBA Terrible Herbs, a Nevada limited liability corporation defendant. Case number A-21-831543-B, Department number 31, punitive damages verdict. We, the jury, return the following verdict. Punitive damages are awarded against Real Water in the following amount: $100 million. Dated the 6th day of February 2024. Jury foreperson. Badge number 61, panel number 18. Ladies and gentlemen of the jury, was this your verdict as read?
Yes.
Do either counsel wish the jury to be polled? Counsels for plaintiff.
No, Your Honor. Thank you so much.
Counsel for defense.
Joel Odou for the Real Water defendants. No, Your Honor. Thank you very much.
Okay, so ladies and gentlemen, I already previously explained what polled meant. Since nobody's asking to be polled, then at this juncture, the court is going to have the clerk record the verdict into the minutes of the court. Thank you so very much. So ladies and gentlemen of the jury, this is the time when we give you the all caps big thank you, okay? And mean that in all sincerity. You sat through 6 days of jury selection. That would be after filling out an extensive jury questionnaire. and then came and sat through the entire trial. You were here on time. We tried our best-ish, so that we tried to get you here as much time. I tried to take the least amount of your time from your very busy lives, and we do appreciate you being here on time, the fact that you were very diligent, the fact that you could tell you were taking notes, listening attentively, et cetera. So on behalf of my entire team here in Department 31, right, Nevada Day, if you want to know why I picked Department 31 to be in, and Trick or Treat, Nevada Day. And so we do really appreciate your willingness to serve our community, because seriously, without each and every one of you willing to do your service, cases on our justice system cannot move forward. So thank you very much. I know I speak on behalf of counsel as well, and their clients, and the various witnesses in this case to thank you as well. On behalf of each of them, I usually give counsel a minute just to say a quick thank you, not a long, loquacious thank you, but just a real quick thank you. If anyone wishes to say thank you. Counsel for plaintiff, would you like to say thank you on behalf of you and your client?
I'm gonna go with thank you, thank you, thank you, thank you, thank you, thank you, thank you.
Same thing for defense.
Your Honor, thank you to the court. Thank you to the court staff. We really appreciate it. I'm speaking for everybody in that regard. Ladies and gentlemen of the jury, thank you very much. We really, really appreciate the effort that you put into this case. Thank you.
Okay, so at this juncture, ladies and gentlemen, your duty as jurors is completed, okay? However, what's the next step? Well, I will tell you on behalf of myself, if anybody's willing to go back into the jury room for a few moments, this court always finds it very helpful just to kind of get a better understanding of certain things that maybe the court can do better, team, et cetera. Can't answer any questions substantively, and I don't answer any substantive questions, but just really to give you a personalized thank you, because you kind of get to see me over here on the bench, but not really, kind of a little bit closer. And so I'd like to say thank you. So if anyone's willing to do that, I would appreciate that. Then afterwards, I will tell you, as you walk out into going to the elevators, oftentimes counsel may be present in the hallways. They may wish to ask you questions. I know when I was in private practice, decades, I used to also speak with members of the jury, because sometimes, to find out just generalized information, to get some input on things that you can, how things were taken when regards to the various things. You might have some questions out there as well. It's really up to you whether you wish to answer any of our questions. Like I said, on behalf of the court, it's always helpful. And usually counsel also find it very helpful. So at this juncture, what I'm going to ask the marshal to do, anybody's willing to go back to the jury room, I'm going to thank each and every one of you. And your jury service is concluded. Thank you so very much.
One last time, please rise for the jury.
On behalf of the court and our team, we want to thank you, Department 31. You all very professional, did this very smooth. Your professionalism among yourselves, much appreciated, because that really helps the case move forward and allows the jury to do its job, allows each of you to do your job. So thank you so very much. On behalf of your clients, thank you for being here and being quiet and not jumping up. And sorry, sometimes we have some very interesting issues, but thank you for not adding to the issues of trial management. So thank you so very much in that regard. And so for the out-of-state counsel, welcome to Nevada. Hope it's all a good experience. And thank you so very much, everyone. So I'm going to go talk to the jury for a brief moment.
Thank you, Your Honor. Thanks to everyone.
Before I get off the record, I'm just going to make sure, is there anything else any party needs? Counsel for plaintiffs?
I thought you said off the record, you said before.
Okay, well, is that a no and a no? Nobody needs anything?
I think we can. Thank you so much. Thanks, everyone.
Counsel for defense? Okay, thanks so much.